There's two things that I like to say when we're dealing with these types of evidence. Is what is my evidence? And then how can I present that evidence in the most persuasive manner to a judge or an arbiter or eventually a jury? If I just present a written statement, guess what? Written statements are boring. Judges tell you the written statements they're going to read and give it all the due weight, but judges are people. Arbiters are people. So if I'm going to develop all this good evidence, and we need to do that to win the case, but then let's present that evidence in a great format. I don't want that written statement. I want the person who actually wrote the statement to come testify live. I want the supervisor, not the workers' comp coordinator.
Absolutely. Let me interrupt and do a ditto on that, Stuart. I can't. That live witness to testify to the statement, crucial. I don't mean to interrupt. Go ahead with your thoughts.
No,
bringing in the supervisor.
Absolutely. Bring in the supervisor. Bring in the witnesses. Have them dressed like they were dressed on the day of the injury to give them some authenticity. If I have a medical report, that's great. But you know what? How about having that doctor testify by telephone if that's possible? If it's by deposition, great. Let's have the video deposition, and let's cut the video deposition to 5 or 10 minutes of really great stuff to highlight. You might put the rest of it in evidence, but highlight the really important stuff. In other words, if you're just presenting written statements that the supervisor got or the employer got, I don't think the attorney's doing his or her job. You got to present it in such a way that, wow, the other side is amazed by it. The judge knows they're going to be there for a while. The judge knows from your reputation that this employer does it right, the attorney does it right, and I have presented this evidence in such a way that, remember, in workers' comp, everybody believes the injured worker. So even though they may have the burden of proof legally, in reality, we must go forward as an employer as if we have the burden of proof. We certainly have the burden of persuasion. And if we go forward with a thought, hey, how do I prove my case? Not, the employee has to prove her case. No, how do we prove our case? And we're going to prove it by persuasive evidence that the other side is going to have great difficulty spending a lot of their political and legal capital trying to combat. There's a much better chance we're going to prevail. So if you pick the right attorney, you get that attorney involved early in the case. That attorney helps you with going for a social, making sure we get the social media before they lock it down, and we get the written statements right. We start making sure that video, which is looped over in 36 hours or 72 hours, that we capture that video, that we do all this stuff early on, working as a team, all of us together. We do all that work when you first look at the case to avoid the litigation, doing the right things, picking the right cases to deny, managing it from the very beginning to when you're presenting the case. We have eliminated fear, and all we now have is the best case we could possibly give to the judge. That's what I want to see. That's what makes, that's what gets me excited.
Which is excellent. Go ahead, Brad.
On the statement, you want to have that statement to keep the witnesses from waffling. One of the lawyer's favorite tactics, defense lawyers' favorite tactics, is the witness gets on the stand and he tells a story that doesn't look anything like his recorded statement. You put the statement in his hand, you make him read the statement back, that those are his words and he signed it, and then we say, well, were you lying then or are you lying now? And clearly you have cut to shreds that witness's credibility on all issues, not just the accident, on all issues, on his complaints of pain, on the length of the TTD. And I would say this, because this didn't come up in our prior discussions. Stuart mentions a video of the job. I would say, and this came to me while we're talking now, I would say the number one problem for my judges is not understanding the job. You understand the job because it's your factory. You understand the job because you've investigated this claim. You've lived with it since the beginning. But sometimes a short video of what the actual job is really relays to the judge whether it is a tough job or whether it is a job that can be done light duty, or it just provides a full level of understanding that is not possible in any other manner.
I know we're getting
Stuart, you got last thoughts?
just to add, not really last thought, but just to add that I couldn't agree more with Brad. Getting a video of the job to educate the judge, because we're not just persuading. We're first educating the judge, and then we are going to persuade the judge. But getting that video of the job does a good job of educating the judge. It also does a great job of educating doctors. I've done that umpteen number of times when a doctor says, "Oh, can't go back to work, can't do the job." Go video the job if you can't bring the doctor out to your site. And once the doctor sees it, it's, oh yeah, they could do that job. That's not what the employee was telling me. Video is if a picture tells if a picture tells 1,000 words, video says millions of words. Use them to your advantage.
So we're at 57 minutes now, and I want to try to wrap this up in sort of some closing, comprehensive type ideals. You guys made a lot of really tremendous statements in this last piece of how do you win. And a couple that I pulled out here that you were just, when you were talking, is the attorney helps working as a team. That was, I think, a very major theme of this entire presentation, of you're bringing that attorney in early. You're having that communication, and sort of I've even talked in the past about having you, the attorney, even look at some of those jobs and understand what those jobs are. So when you're going to now present this, not only are you educating the judge and the doctor, you're educating your attorney about what this works, what this looks like, so that you pick the right cases to deny. You pick the right cases to deny. And the best way for you to know which cases those are is to work with your defense counsel that's a part of your team. Some of them should be denied, some of them shouldn't. Knowing the difference is the key to this entire presentation. And you do that by having that right defense counsel relationship. You guys talked about video quite a bit now. All of us have our phones, boom, they're right in our pockets, you whip it out. Pretty easy to just take a real quick video of the job. It's not overly complicated. Everyone knows how to use it. Everyone knows how to send it. Everyone knows how to transfer it. Everyone knows how to use this piece. But if we're not using it to our advantage, then we're missing some of the boat in presenting this case. We talked about a lot of very specific things here. One of the overarching things of having these live witnesses, having the supervisor there, is really this element of care. And so we talked about, do you care about your employees by sending them a get well card? Do you care about your employees authentically by having an employee brochure? Do you care about your company enough to be present at the hearing? And both of these gentlemen stipulated how important that is when they're making their argument, making their presentation to the judge of not only what your evidence is, but how credible is it? How believable is it when you're there? I thought that point you made, sort of, are they wearing the same clothes they were that day? A very subtle but potentially important point of increasing the presentation, and the credibility of that entire thing, and educating these judges. This was a great point, Brad. Not understanding the job and the doctors is a huge piece of that, and we've done various trainings on educating those doctors. So very important. Jay, is where does the prior medical enter the discussion? So good question, Jay. Where does the prior medical meaning, sort of what exactly you mean by that, Jay? The comorbidities, if they have an existing relationship, if you want to expand. Stuart or Brad, maybe you know more of what Jay's talking about there.
Yeah, I think what he's probably getting at is if there's a previous complaint about damage or harm to the physical structure of the body that occurred prior to the alleged date of injury, as early as possible, obviously. If you know that the claimant was limping or had an injury at a softball game 6 months before, boy, get that to me early on. That's going to be part of the process of evaluating the case. It's going to change what kind of discovery we want to accomplish very early on. It's going to determine where we want to send subpoenas if we don't get a medical authorization. So it comes in early, and then every waking moment he tells other doctors he's never had any problems, and we find out that he was limping beforehand. Boy, if we can get video of him limping or social media of him limping around 4 months before, but he tells his doctor, I've never had a problem, I just destroyed his credibility. It might not have a single thing to do with the case, except the fact now he's not a credible witness. You destroy the credibility, you increase the odds of winning that case. Now, that's state specific, because some states the credibility is less important, But as soon as we get that evidence, let's develop it and let's put it in a very persuasive format.
And I think it goes back to that, really that second point of the early engagement, having that discussion beforehand and saying, what do you think about this? Hey, they've got this prior medical, what do you think we should do here? And that's going to really help to really make that answer clear. So we're at 61 minutes now. I want to go ahead and wrap up. So I'll leave it to you, Brad, for the last statement. And then what we're going to do from here, just from an administrative standpoint, we're going to take about a 1-minute break. And then following this, we have our mastermind advisory session. So those that want to go a little further, have a little bit more of a one-on-one discussion, I invite you to stay on the call, but the formal part of the presentation will be over. So Brad, to you for the last thoughts here.
Just to the question on documents of pre-existing condition. Those are very important for your IME doctor. Ultimately, that's a medical question on whether this is a new injury or a continuation of an old injury. And the need for that opinion may very well influence who Stuart or I recommend for an IME doctor. Hey, we want to get that other MRI from that old injury. We want the records, and we want this doctor because he's held highly credible at the commission. And if he says it's our baby to pay, then we got to pay it. But if he at least he's got the meat in his hands to say, no, this is all a pre-existing condition. This is just more symptoms of the same. So it's a medical question on whether it's aggravated or accelerated by this injury, but that may influence Stuart and I's opinion on who you use for an IME.
Excellent.
And that's it. That's just to the point of the question. Sorry, Mike.
Oh, no problem. I thought it was great. So I want to thank both of you, gentlemen, Stuart and Brad, for your expertise, your knowledge. I thought you guys were great. We kind of stuck pretty close on time, about 7 minutes over, not the end of the earth here. Jay, your question put us over the top, so we'll put the blame on you. But overall, I want to thank you guys for your participation. Thank everyone for attending this session. As I mentioned, if you want to stay on for the Mastermind Advisory session, that's where we'll have really a more discussion type format of not really a presentation style, but more discussion style. And I welcome you to do that. That'll be about 20-25 minutes or so following this call. So I'll take about a 1-minute break, and then those that want to stay on past that are certainly welcome to. So thanks again, Stuart. Thanks again, Brad, and thanks everyone for attending.